Did you know that there once was a lawsuit, this lawsuit, claiming that it was illegal for Queen Elizabeth II to call herself by that name? Yeah, the lawsuit claims that Queen Elizabeth, this one, was not Elizabeth II, and therefore she could not call herself the second. I bet you're saying, no, she was the second. This one was the first. Well, let me tell you a story that was the basis for the lawsuit. Before 1707, Scotland and England were two separate countries. You've seen Braveheart, the movie. You know the Scottish people fought a war of independence. It was not until 1707 that the two countries merged into Great Britain, and Queen Anne of England also became the Queen of Scotland. The law regulating the merger of the two countries and the creation of this new Union Jack was the 1707 Act of Union or Treaty of Union. That means back 100 years before that, when this Elizabeth was queen, she was not the Queen of Scotland, and Scotland has never had a Queen Elizabeth. Therefore, when this Elizabeth came around, she was the first time Elizabeth, Queen of Scotland. And that was the basis for the lawsuit. The lawsuit here, McCormick versus the Lord Advocate, was a serious constitutional lawsuit raising the issue of whether or not when the Queen called herself Elizabeth II, whether or not it was a violation of the Treaty of Union, because in a way she was not respecting the separate past of Scotland. And I was told by people who practice constitutional law in the UK that this was a serious case raising serious constitutional issues. But as far as the specific of the case concerned, it didn't go anywhere. Basically, the court said this was not a justiciable issue. They say that the question of what the monarch called herself was not justiciable. In other words, what they're saying is that as judges, there's nothing that us as judges can do about the way the Queen called herself.